I'm Brenda Malcolm, and I've been practicing corporate law for 8 years now. 8 years of 18-hour days, weekend sacrifices, and missed family dinners. 8 years of proving myself in a profession where being a woman means every opinion gets scrutinized twice as hard, every mistake gets remembered twice as long. I've worked my way up from a junior associate making $165,000. A year sounds like a lot until you divide it by the actual hours worked as senior associate. Handling complex merger and acquisition deals that most lawyers would kill to touch. My specialty. Finding the problems nobody else wants to look for. I'm the lawyer who reads the footnotes, who digs into the appendices, who cross-references regulatory filings at 2 a.m. because something feels off. It's not glamorous work, but it's essential. I've caught SEC compliance issues that could have triggered federal investigations. I've identified intellectual property conflicts that would have resulted in multi-million-dollar lawsuits. Last year, I discovered a chain of subsidiary ownership that revealed our client was unknowingly acquiring a company with ties to sanctioned entities. A discovery that saved them from potential Treasury Department penalties. So when partner Gregory Thompson dismissed my analysis on the Morrison Industries merger like I was some first-year intern fetching coffee, it didn't just sting it, revealed everything wrong with the power dynamics at our firm. But when he came storming into my office 2 days later, screaming about the very issue I'd flagged, that's when I knew something fundamental had to change, not just for me, but for every associate who'd ever been silenced by ego disguised as authority. Let me back up. The Morrison Industries acquisition was a $400 million deal, the kind that makes headlines in the Texas Business Journal and determines whether partners get their 7-figure bonuses. Morrison Industries manufactured industrial equipment across 7 states, with a particularly heavy footprint in Texas, Louisiana, and Oklahoma. Our client, Apex Manufacturing Group, saw this as their opportunity to dominate the Southwest market. I'd been assigned to lead the environmental and regulatory due diligence TEMA responsibility that typically went to partners, but needed someone who could work the brutally long hours without complaining about missing their kids' soccer games. My team consisted of 2 junior associates, a paralegal, and me, tasked with combing through 47 boxes of documents, digital files spanning 12 years, and regulatory filings in 4 different states. It was the kind of tedious, deep work that separates good lawyers from great ones. Most people see corporate law as glamorous, expensive suits, client dinners, handshake deals worth hundreds of millions. The reality is countless hours in windowless conference rooms reading contracts with the intensity of a forensic accountant, because one missed clause can destroy everything. I actually loved this part of the job. There's something deeply satisfying about building a complete picture from scattered pieces, like solving a puzzle where each document reveals another layer of the story. I'd developed a systematic approach over the years. Environmental compliance first, because that's where companies hide their biggest nightmares. Then regulatory filings, looking for patterns or inconsistencies. Finally, the corporate structure itself, mapping relationships that might create unexpected liabilities. 3 days into the review, I found it, buried in Section 47.3 of their environmental compliance documentation. Hidden in language so technical it would make most lawyers' eyes glaze over, was a clause that essentially made Morrison Industries liable for cleanup costs at 3 former manufacturing sites in East Texas. The sites had been abandoned since the 1980s, but recent EPA assessments suggested potential groundwater contamination from industrial solvents. We weren't talking about minor environmental issues. The preliminary estimates suggested cleanup costs could range from $20 to $40 million costs that would become Apex's responsibility the moment the acquisition closed. I'd seen similar language torpedo deals before, and I'd also seen acquiring companies get blindsided by environmental liabilities they never saw coming. I immediately drafted a comprehensive memo outlining the risk, complete with EPA precedent cases and suggesting 2 potential solutions. Either negotiate a significant price adjustment to account for the potential cleanup costs, or require Morrison to establish an escrow fund specifically designated for environmental remediation. I also recommended bringing in an environmental consulting firm to conduct independent soil and water testing at all 3 sites before closing. The memo was 12 pages of detailed analysis, case citations, and risk assessment. I was proud of it. It was thorough, professionally written, and could potentially save our client tens of millions of dollars. I printed copies for the entire team and scheduled a meeting with Thompson to discuss our findings. That's when I walked into what I can only describe as the most professionally humiliating moment of my career. That's when I walked into what I can only describe as the most professionally humiliating moment of my career. Thompson was holding court in Conference Room B, our firm's second largest meeting space with floor-to-ceiling windows overlooking downtown Austin. The room reeked of expensive cologne and that particular brand of masculine confidence that comes with billing $800 an hour. He was surrounded by 3 other partners and 2 executives from Apex Manufacturing CEO, James Hartwell, and CFO Susan Torres, both of whom I'd briefed on previous aspects of the deal. I knocked, waited for his nod, and stepped inside with my analysis, feeling the weight of 12 pages of potentially deal-saving research in my hands. "Gregory, I need to flag something critical in the Morrison environmental docs," I began, setting the memo in front of him. "There's potential liability that could significantly impact the acquisition price." He didn't even look up from his papers. The dismissal was so casual, it felt almost rehearsed. "Legal doesn't need your analysis. Brenda, we've got this handled." The words hit me like a physical blow. I could feel the heat creep up my neck, that familiar flush that comes when you're a professional. Competence gets questioned in front of clients. But this could expose our client to environmental cleanup costs in the tens of millions. I said, "We've got it handled." His voice carried that sharp, dismissive edge I'd heard him use with junior associates, but never with me. He finally looked up, and his expression made it crystal clear that I was not just interrupting. I was actively wasting the time of very important people with very important money. The silence that followed was deafening. CEO Hartwell shifted uncomfortably in his chair, his eyes darting between Thompson and me. CFO Torres suddenly found her smartphone fascinating. The other partners, Williams Foster and newly promoted Rodriguez, became intensely focused on their legal pads, as if the most interesting contract language in legal history had suddenly materialized there. "Unless you have something actually urgent," Thompson continued, his tone now carrying a warning, "I suggest you get back to your billable hours. I'm sure you have plenty to keep you busy." I stood there for what felt like an eternity, but was probably only 5 seconds. Time seemed suspended as I processed what had just happened. This wasn't about being busy or having a full agenda. This was about hierarchy, about who gets to speak in rooms where millions of dollars are at stake. This was about Thompson establishing, in front of clients and partners, that my 8 years of experience, my expertise in environmental compliance, my 12-page analysis, none of it mattered when he decided it didn't. I managed a professional nod, backed out of the room, and closed the door behind me with the careful control of someone who refuses to give her critics the satisfaction of seeing her rattle. But inside, I was furious, confused, and questioning everything I thought I understood about my place in this firm. I spent the rest of that day in a strange, disconnected state, going through the motions of my normal routine while my mind replayed the conference room scene on an endless loop. Was I overreaching? Had I misread the political dynamics of the meeting? Maybe Thompson had already identified the environmental issues and had a plan I wasn't aware of. Maybe I'd committed some breach of protocol by bringing concerns directly to him instead of following some chain of command I didn't understand. But the more I thought about it, the angrier I became. I pulled the Morrison documents again, spread them across my office floor like a crime scene investigator, and reread every page of the environmental compliance section. I cross-referenced the abandoned sites with EPA databases, finding records of groundwater monitoring, reports that painted an even bleaker picture than I'd initially realized. I called my former law school professor, Dr. Elizabeth Murphy, who specializes in environmental compliance law at UT Austin. "Brenda, this is a textbook example of successor liability," she told me after reviewing the documents I'd emailed. "Any competent environmental attorney would flag this immediately. The cleanup costs could easily reach $50 million or more. If there's groundwater contamination, your clients would be insane to proceed without addressing this." I also reached out to Tony Vasquez, a former colleague now working at an environmental consulting firm. His assessment was even more dire. Those sites were major manufacturing facilities in the 1970s and 80s. Back when environmental regulations were basically non-existent. "I'd bet my license there's significant contamination. Your client needs independent testing before they touch this deal." Every expert I consulted confirmed my initial assessment. This was a massive red flag that could destroy the acquisition, or saddle Apex with potentially catastrophic liabilities. Yet Thompson had dismissed my concerns without even reading my analysis. The next morning, I tried a different approach. I revised my memo, making it even more concise and focused, and sent it directly to Thompson via email with copies to the other partners on the deal team. I marked it urgent, potential deal killer, and requested a 15-minute meeting to discuss the environmental liabilities. His response came 30 minutes later. Brenda, I appreciate your thoroughness, but environmental issues are being handled at the partner level. Please focus on your assigned document review tasks. GT, that email felt like a door slamming shut. Not only was my legal analysis being ignored, but I was being explicitly told to stay in my lane to stick to document review, while the real lawyers made the important decisions. It was infantilizing and professionally devastating. But Thompson had made it clear my input wasn't welcome in the rooms where decisions got made. 2 days later, I was deep into document review for another CASA software licensing deal that should have been straightforward but was turning into a regulatory nightmare when my office door flew open. No knock, no excuse me, nothing. Thompson stormed in like he owned not just the firm but every molecule of air I was breathing. His face was red, that particular shade of crimson that comes from high blood pressure, too much caffeine, and the kind of rage that makes people forget they're supposed to be professionals. He was holding a stack of papers that I immediately recognized. The Morrison Industries environmental compliance documents, now marked up with highlighter and angry red ink. Why didn't you flag this clause? He slammed the documents on my desk with such force that my coffee cup jumped, sending dark liquid splashing across my keyboard. The violence of the gesture was clearly intentional. This wasn't just about getting my attention. This was about dominance, about making sure I understood exactly how much trouble I was in. I looked up from my laptop, trying to process the complete reversal of our previous interaction. The same man who had dismissed my analysis as unnecessary was now furious that I hadn't been more insistent about the very issues I'd tried to raise. I did flag it, I said carefully, my voice steady despite the adrenaline coursing through my system. I brought it to your attention in conference room B on Tuesday afternoon. I also sent you a detailed memo via email. No, you didn't. The words came out flat, definitive, as if he could rewrite history through sheer force of will. I blinked, trying to understand if this was some kind of elaborate gaslighting or if he genuinely didn't remember our interaction. Gregory specifically told you about Section 47.3 and the environmental liabilities at the abandoned manufacturing sites. You told me that legal didn't need my analysis. I would have remembered something that important. His voice carried absolute conviction, the kind of certainty that comes from someone who's never had to question whether their version of reality would be accepted without challenge. The gaslighting was so blatant, so professionally insulting, that I felt something shift inside me. This wasn't about a miscommunication or a busy schedule. This was about power, about whose voice mattered, and about a man who would rather destroy my credibility than admit he'd made a catastrophic error in judgment. I have the email thread, I said quietly, turning my laptop screen toward him. Sent Tuesday at 4:47 p.m., marked urgent. Your response is right here. Environmental issues are being handled at the partner level. For just a moment, I saw something flicker in his eyes. Recognition he knew exactly what had happened. But admitting it would mean acknowledging that he'd dismissed critical information because it came from me as senior associate rather than another partner. It would mean admitting that his ego had potentially cost the firm and the client millions of dollars. The client is furious, he continued, his voice rising to a level that I was certain could be heard through the thin walls of our office building. James Hartwell called me at home last night. At home, Brenda. Do you understand what that means? They're threatening to pull the deal entirely and pursue malpractice claims against the firm. Morrison's environmental consultants have now provided preliminary estimates, suggesting cleanup costs could run anywhere from $20 to $40 million. $40 million. How did we miss something this massive? We didn't miss it, I said, standing up from my chair to meet his gaze directly. You chose to ignore it. The words hung in the air between us like smoke from a discharged weapon. I could see him calculating his next move, weighing the political implications of various responses. Thompson was known throughout Texas legals for his explosive temper, but he was also ruthlessly strategic. Completely losing control over a senior associate would raise questions he didn't want to answer, especially since our conversation was almost certainly being overheard by the associates in neighboring offices. I want a full report on how this oversight occurred, he said finally, his voice now controlled but carrying an unmistakable threat. I want to understand every step of the due diligence process, every communication, every decision point that led to this failure. on my desk by tomorrow morning. And Brenda, he leaned forward, lowering his voice to just above a whisper. I suggest you think very carefully about how you characterize the events of this week. Memory can be such a tricky thing, can't it? The implicit threat was crystal clear. Write the report in a way that protects Thompson's reputation and spreads blame elsewhere, or face consequences that could derail my career at Texas Legals and, potentially, in the broader Austin legal community, where Thompson's connections ran deep. After he left, slamming my door hard enough to rattle the framed law degree on my wall, I sat in my office staring at those documents, feeling something I hadn't experienced since my first year as an associate. The cold, creeping fear that comes when you realize how little power you actually have in situations that could determine your professional future. But alongside the fear was something else. Something cleaner and more focused. Pure, crystalline anger. Not the hot, impulsive rage that makes people do stupid things, but the cold, analytical fury that makes strategic thinkers dangerous. This wasn't about a miscommunication or a busy partner overlooking details. This was about power, about whose voice mattered in rooms where millions of dollars were at stake, and about a system that protected partner egos while destroying associate careers. And I was suddenly seeing this pattern with absolute clarity. Not just in my own experience, but in the experiences of colleagues I dismissed as isolated incidents or personality conflicts. That evening, instead of going home to my apartment in South Austin, where I'd probably spend the night spiraling into self-doubt and anxiety, I did something I'd never done before. I reached out to other associates and junior partners, not for gossip or commiseration, but for a systematic conversation about working conditions and decision-making patterns at Texas Legals. I started with Lisa Foster, a corporate finance specialist, who'd joined the firm 2 years after me. We met at Radio Coffee on Barton Springs Road, neutral territory where we could speak freely without worrying about who might overhear. Lisa, I said after we'd settled into a corner booth with our drinks, I want to ask you about something, and I need you to be completely honest with me. Have you ever had the experience of raising a legitimate legal concern and being dismissed, only to have that concern become a problem later? Her laugh was bitter and immediate. God, Brenda, where do I even start? Last month, I raised concerns about a potential patent dispute that could affect the Zentech acquisition. The target company had developed software that looked remarkably similar to technology already patented by a German firm. I suggested we conduct a comprehensive patent search and possibly reach out to the German company to assess their enforcement strategy. She paused, stirring her latte with the kind of methodical precision that suggested she'd replayed this story many times in her head. Partner Williams looked at me like I'd suggested we hire an astrologer for legal advice. Technology isn't your area, Lisa, he said. Let the IP team handle intellectual property issues. Except the IP team was focused on trademark concerns and completely missed the patent conflict. What happened? 3 weeks later, the German firm filed suit in federal court, seeking an injunction that would have shut down the target company's entire software platform. Suddenly, it's my fault for not pushing harder, for not being more insistent about the patent search. Williams actually said, "Why didn't you make this sound more urgent?" As if dismissing my analysis as outside my area of expertise was somehow my communication failure. I felt my stomach tighten as Lisa's story confirmed what I was beginning to suspect. How much did that cost the client? The deal fell apart entirely. Zentech walked away rather than risk acquiring a company that might not be able to operate its core product. We're talking about a $180 million acquisition that died because a partner couldn't be bothered to listen to a senior associate's legitimate concerns about patent infringement. From Radio Coffee, I went to drinks with Michael Rodriguez, one of our tax specialists, at the Driscoll Hotel bar. Michael was normally one of the most diplomatic people at the firm, someone who'd mastered the art of raising concerns without ruffling partner egos. But when I asked him about experiences with dismissed analysis, his composure cracked. "The Riverside real estate deal," he said immediately, as if he'd been waiting for someone to ask this exact question. I flagged potential tax implications with the partnership structure they were proposing. The way they'd organized the ownership entities could have triggered passive activity loss limitations that would have cost the client millions in unusable tax deductions, and let the tax team handle tax issues. "Michael," he said, mimicking partner Foster's dismissive tone with startling accuracy, "except I am the tax team for real estate transactions." When the IRS challenged the structure 6 months later and disallowed $12 million in deductions, somehow it became my fault for not being more persuasive in my initial presentation. The pattern was becoming undeniably clear. but I needed more data points. Over the next 2 days, I had similar conversations with junior partner Sarah Kim, senior associate Antonio Valdez, and even second-year associate Jamie Wong. Every conversation revealed the same. Dynamic associates would identify legitimate legal issues, get shut down by partners who didn't want to hear about complications that might delay deals or require additional work, and then get blamed when those issues exploded into expensive problems. But the conversation that truly crystallized my understanding came from an unexpected source, Partalego Madia Santos, who'd been at Texas Legals for 12 years and had worked with every partner in the corporate department. "Ms. Malcolm," she said when I approached her near the copy machine, "can I speak frankly with you?" "Of course, Maria, and please, call me Brenda." She looked around to make sure we weren't being overheard, then leaned closer. "I've been keeping track of situations like what happened to you with the Morrison deal. Not officially, you understand, but in my own notes. It's happened at least 15 times in the past 2 years that I can document. Associates raise concerns, partners dismiss them, problems develop, associates get blamed. 15 times. At least, and it's not random, there's a pattern to which associates get dismissed and which concerns get ignored. It's almost always women and minorities who get shut down. And it's almost always issues that would require partners to do additional work or admit they missed something in their initial analysis." Maria's observation hit me like a revelation. The dismissals weren't just about ego or workload management. They were about maintaining a hierarchy where certain voices simply didn't matter, regardless of their expertise or the validity of their concerns. But here's what Thompson didn't know. I'd been documenting everything, every email, every memo, every meeting note. When you've been practicing law for 8 years, you learn to protect yourself with paper trails. I spent that weekend crafting a different kind of memo, not the incident report Thompson wanted, but a comprehensive documentation of the Morrison Industries situation, complete with timestamps, witness statements, and copies of my original analysis. I also reached out to Lisa, Michael, and 3 other associates who'd shared similar experiences. Monday morning, I didn't go to Thompson's office. Instead, I walked into managing partner Amanda Stevens' office with a folder that contained not just my Morrison Industries documentation, but a pattern of dismissive behavior that was actively damaging client relationships and firm reputation. Stevens listened without interrupting as I laid out the situation. I watched her expression shift from polite attention to genuine concern as I presented case after case of associates being silenced, then scapegoated. "Brenda," she said finally, "these are serious allegations. If what you're telling me is accurate, we have a significant leadership problem. The associates involved are willing to provide formal statements." I told her, "This isn't about personal grudges or office politics. This is about client service and professional accountability." That afternoon, Stevens initiated a formal review of Thompson's cases and management style. The investigation was discreet but thorough. Within 2 weeks, a clearer picture emerged. Thompson's dismissive leadership had contributed to client complaints, case delays, and associate turnover that was costing the firm significantly more than just billable hours. The reckoning came 3 weeks later. Thompson wasn't fired, partners rarely are, but he was quietly removed from the Morrison Industries case and passed over for the lead role on Austin Bank's massive corporate restructuring, a position he'd been angling for all year. The message was clear: behavior has consequences. More importantly, Stevens implemented new protocols for case management and team communication. Associates now have clear channels for raising concerns, and partners are evaluated not just on revenue generation, but on team leadership and client outcomes. The Morrison Industries deal, we salvaged it. With Thompson out of the way, I was able to work directly with the client to structure an escrow arrangement that addressed the environmental liabilities without killing the acquisition. The client was so impressed with the solution that they've since brought us 3 additional deals. But here's what I learned from this experience. Your voice matters. Especially when people try to silence it. The issues you identify don't disappear because someone dismisses them. They just become more expensive to fix later. If you're in a similar situation, document everything. Find your allies, and don't let anyone convince you that your expertise doesn't matter. Sometimes the most important thing you can do is refuse to be invisible. What's your experience been with workplace dynamics like this? Have you ever had your professional input dismissed, only to be blamed later when problems emerged? I'd love to hear your stories in the comments below.